everybody doing today? We're doing okay. Who is ready for a nap? Right? So I think this is what you might know. Is this my fourth year doing ethics? First, I want to say thank you to everyone who keeps filling out those surveys and saying they love my ethics presentations, because then guess what I get to do next year? The most exciting topic. And we decided to have us present ethics after lunch, because we know you guys are your most alert after lunch for this very exciting topic of ethics. So we do our best of trying to make ethics fun and exciting and educational. If you have any questions, just let us know. We'll sweep through. I am not licensed in Missouri. I am only licensed in Wisconsin. So my man Dan here is here to answer all of your questions. But we'll start off with how our presentation today is going to be how to be OC about the OCDC. And I had a caution. I'm like, I know what like OC, like obsessive compulsive about the OCDC, but it was just there to be a little fun. All right, for some of our regulars, you know that we like to start off with a brief update based on the information we received from the OCDC in the prior year. So all these stats are based on the release from the OCDC in 2016, which is based on 2015 stats. So for those of you who have attended the presentation every year, this data is always a year behind in terms of release. There were 1,995 complaints of attorney misconduct were received in 2015. That's up about 78 complaints from 2014. The formal investigations and cases investigated by the Regional Disciplinary Committee, they're also up. And it's worth noting that the cases investigated by the OCDC, though, is down by 32 cases. So, the number of OCDC's informal resolution program is up slightly from 42 the prior year to 2015 was 48. And there were 54 more investigations that were not opened in 2015 versus the prior year. The number of cases within insufficient information was down from 65 to 48 from the prior year. And also there were fewer cases that were referred to the fee dispute committee, down from 40 to 17. But far more, 31 from 18 were placed in inquiry status, where the cases were not opened but were monitored to determine whether an investigation should be opened in the future. Now on to your summary of disciplinary actions. 18 lawyers were disbarred. That's down from 25 lawyers, so improvement. 27 lawyers were suspended, with 11 of those stayed pending probation. This is also down from 30 in 2014. 83 lawyers received written admonitions, which is down from 93 in 2014. 11 lawyers were suspended for failure to pay taxes. Again, this is down. There were 36 in 2014. So yay, we are better at paying our taxes. 4 lawyers received public reprimands. That number doubled. It was 2 in 2014. And 164 cautionary letters were sent to lawyers by the OCDC and the regional committees. In 2015, we saw a total of 132 disciplinary actions, including admonitions and formal discipline matters. The top 4 complaints were the same in 2015 as they were in 2014. Communication, 360 complaints. Diligence, 344. Safekeeping property, 185. Improper withdrawal, there were 100. Dishonesty, fraud, deceit, misrepresentation, 99. This one was up. That was the 6th spot last year. Now it's up to the 5 spot. Excessive fees went down. It was actually the 5 spot. There were 87. Conflicts, there were 73. Competence, there were 26. Truth to the tribunal, if I can say it, it will be the truth. It's 25, and unauthorized practice was 19. And keeping at our number 1 spot, the top area of investigation was, again, domestic. It had 174 investigations. Criminal is still the close second at 146 investigations. So now that we're all feeling appropriately unnerved, right? It doesn't feel good to talk about ethics violations and reports of lawyer misconduct. We are here today, however, to help everyone start an action plan. Whether you've been practicing for a month or 30 years, today's presentation is going to highlight a few different topic areas that relate to ethics and your practice. When I go to CLE presentations, I find myself listening to the first part of the presenter's presentation, and my mind wanders. Didn't take my Adderall today. And think about all the things that I should be doing differently. Right? Your mind starts wandering like, oh, and it even sounded like in Raul's presentation, there was the, oh crap, I need to start doing something different, right? So now, it's a fair thing to say when I do absorb a presentation, especially one as captivating as ethics, I create my action plan. I write the action plan down and I implement it. So as you listen to the presentations today, and this presentation in particular, we're going to recap at the end, and we're going to get interactive, because I know you're all just thinking about, how great lunch was. So we need to keep you engaged. So we're going to share with you, and we're going to share with each other what we're going to do differently tomorrow, so we can motivate ourselves and others to up our game when it comes to being OC about the OCDC. So next, we're going to talk about joint representation. Dan?
All right. It's good to be back. When I was asked to help out, I was like, I only want to do it if I can talk about ethics, because it's just so interesting. And then Erica and I were talking, and we're like, well, what can this topic be? And she likes to make fun of me sometimes because I'm a little OC about certain things. And I said, I'm OC about the OCDC, and nothing scares me more, even more so than talking in front of a large group of people, than the OCDC. Frightening, very frightening. So the first topic, as Erica said, is joint representation. So what is it? Is it good? Is it bad? What are the risks? Part of the presentation is definitely be a little dry, maybe a little boring, because we got to recite some rules, and we're going to have to read from script a little bit. But then we're going to get a little more interactive, a little bit more fun. Right before that lunch starts to kick in, Eric and I will start making it a little bit interactive for us all. So the more participation we have, I think it's going to at least be a little bit more interesting, and we can get through the next couple hours together. If there's questions, we'll try to answer them throughout. We'll hopefully be able to wait till the end, but if not, again, we'll try to answer them as best as we can. But we have a lot of information, a lot of great topics that we've brought into this presentation. We've had some really good ones so far this morning and a few more in the afternoon. And they all kind of tie in together. And a lot of this information that we're going to talk about as we proceed through this presentation is going to be on social media. That's really kind of a hot topic. It's a trend. I can tell you that when I was doing some of the research for this, that there's more out there than just Facebook. I'm not really an Instagram person or a Snapchat or a Twitter, or I don't tweet, I don't blog, but it's all out there. We're going to cover it, so hopefully you find it at least informative. So joint representation, what is it? Two or more parties in the same matter sometimes seek to hire a single lawyer. This could be good, it could be bad. The client's perspective may be, well, let's hire one lawyer. We can save on costs, save on time. We've agreed to everything. Why do I need to hire my own separate attorney? Well, that may impose some disadvantages. So when a problem arises, disciplinary complaints and malpractice actions may result. Lawyers should carefully analyze the facts and apply the rules of professional conduct before agreeing to joint representation. So let's see, what is the rule? Rule 4, 1.7. The comments provide the steps a lawyer must take to address a conflict of interest problem. This is going to get a little boring, but then we're going to start to get a little interactive. So what exactly is the rule? 1, clearly identify the client or clients. 2, determine whether a conflict of interest exists. So far seems pretty straightforward. 3, decide whether the representation may be undertaken despite the existence of a conflict, whether the conflict is consentable. And 4, if so, consult with the clients affected under Rule 4.17a and obtain their informed consent confirmed in writing. So here we go. There's 4 steps to joint representation. What are they? First one is, who is the client? This is important to identify. And earlier in some of the presentations, we've mentioned the initial meeting with the client, whether it was in Scott's presentation, Raul's, Dorothy's, Sam. I know they all mentioned the importance of the initial meeting, whether it's setting expectations. Here, we're focusing on who is the client. I know a lot of times we'll have people come in and they're going to bring another person with them, a third party, and they think, hey, we have everything all ready to go. We just want to hire you to do this. Well, we need to really figure out exactly who the client's going to be, because one thing that we want to make sure we're not doing, and I'll go into more detail as will Erica later on in the presentation, is accidentally creating an attorney-client relationship. So that's one thing in the very beginning. We want to make sure that we establish who is the actual client. So then step 2, is there a conflict? So how do we do this? The first thing to remember, oops, I'm going through it a little too fast. Here we go. Is there a significant risk that the representation of a client will be materially limited by the lawyer's responsibilities to another client? Again, even if you have, for example, since the majority of us in this room probably practice domestic relations law, we have a husband and wife come in, they have everything ready to go, they agree. As we know, once we get into the process, that's not always the case. Issues arise. Same thing in an initial meeting. The client will come in, you meet with them, they'll tell you one thing, and then as the representation continues, either that issue that they've been talking to you about is not true, or there's more to it. And so as we continue on in the representation, there may be some things that materially affect us being able to represent both husband and wife in that situation. Another thing to point out is generally clients' interests are directly adverse, do not want to share an attorney. I as a practice, don't do this, and as a firm, we don't either. It's not a good idea. You don't want to be in a position where you have to withdraw, and now instead of representing one client, you're not representing any clients. Another thing to remember is opposing parties in a lawsuit may not be jointly represented. Clients may not realize their interests are directly adverse. Again, going back to the example where husband and wife think they have everything figured out, and then once you really get into it and kind of break it down to make sure that they understand what they're agreeing to, their interests could become adverse. And now you're in a situation where you're not going to be able to represent either one of them. One thing I want to point out is with regard to the material limitation conflict, lawyers must determine whether there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. The lawyer must perform adequate due diligence to measure the risk that his or her ability to consider, recommend, or carry out an appropriate course of action for the client will be materially limited as a result of the lawyer's other responsibilities or interests. To analyze this issue, the lawyer should question the prospective clients at the outset. The lawyer must be careful, however, not to prematurely create an attorney-client relationship. Again, we're going to go into more detail about this later on in the presentation. Lawyers should clearly state during this investigation that they're not yet representing the prospective client and disclose where they already have a client in the matter. So step 3. So we got step 1, who is the client? Step 2, is there a conflict of interest? And then now step 3, is the conflict consentable? So conflicts that are not consentable, how many do you think there are? There's a couple situations that the conflicts are not consentable. Well, there's 3. 1, conflicts in which the lawyer cannot reasonably believe that he can provide competent and diligent representation to each affected client. 2, conflicts in which the representation is prohibited by law. And 3, conflicts in which the representation involves assertion of a claim by one client against another client in the same litigation or other proceeding. If any one of these 3 is present, then the issue of consent is not reached. And then lastly, we said there was 4. So step 4 is, can you obtain informed consent? The clients likely in this situation, as I mentioned earlier, are more focused on the cost saving and the time perspective from shared representation. However, as lawyers, we have to do our due diligence, and part of that due diligence is going to be educating the clients on the risk as far as if we're representing both of them. So Rule 4-1.0e defines informed consent as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risk of and reasonably available alternatives to the proposed course of conduct. When representation of multiple clients in a single matter is undertaken, the information must include the implications of the common representation, including possible effects on loyalty, confidentiality, and the attorney-client privilege and the advantages and risks involved. One of the things that I like to do when I'm presented with this particular situation is make sure that both parties understand the risk involved. Even if they think that everything is already agreed to, we as lawyers, we need to do our due diligence. It may not be in the guise of formal discovery, but we want to make sure that we're looking underneath every stone, we're dotting our I's, we're crossing our T's, because we don't want to be in a situation where if they think that everything is settled and then they have regrets, then it comes back to us. So let's move on to action time.
Well, let's first do an exercise. Can I have everyone please raise your hand very high in the air? I'm just checking to see who's listening, who's not. All right. Now we know you're all capable of it. And we're getting... Hi.
Are you seeing people falling asleep already?
We're just making sure.
Okay. Well, I changed it back because I want to give away our examples here.
All right. So we're going to have some action time.
Let's do it.
Let's do it.
Okay. Here we go. Ready? Now the fun begins. All right. I like the enthusiasm. Thank you.
All right. So the first one is...
All right. Husband and wife in a divorce. I know I've kind of really talked extensively about this, but what are your thoughts as far as if we should represent them or not?
Well, maybe we should go through the 4 steps.
That might not be a bad idea. Is there 4 or how many did I say there were? Is anybody paying attention? 4. You sure? Did I say 4?
I feel like you're... Okay, I have a 2-year-old, and I'm like, this really works, right? What he's doing, it works. All right, so 4 steps. First one, what is the first step when you have anybody in the front row? By the way,
I know
did
the
you guys
answer.
notice everybody in the front row got a wonderful water bottle? It's good to be in the front row. But anybody want to raise their hand and walk through the first step?
You're reminding me of law school days. I'm getting scared up here.
Well, the Socratic, I would just say, you in the orange cardigan. That's you.
We're not making friends up here.
All right, anybody?
Identify the clients.
Identify the clients. This is kind of easy.
Yes.
So what do you think it is?
The husband and wife.
All right, we did step 1. Husband and wife are the potential clients. Step 2?
Determine whether a conflict exists.
What do you think?
Yes.
Okay. There is a conflict.
Probably.
Step 3?
I mean, I don't know they're coming in for.
Step 3.
Consent.
Can we obtain consent?
Yes.
You think we can obtain consent?
No, I don't.
Okay. So this is a no-go. You are not recommending that we represent a husband and wife in divorce. Correct. Is that your legal opinion?
Yes.
Okay. Fine, he says no. Sorry. Husband and wife, we're not representing you in a divorce.
But what if they really, really want us to represent them?
So that's a no.
I'll sign a waiver.
Nope. No waiver can be signed.
Well, that's not fair.
Okay. Now, in situations like this, in my practice, I have quite a few situations where they do have an agreement, and they are looking for an attorney to, quote unquote, just draft the agreement. And what you'll do is you'll emphasize, I need to pick one of you. One of you is going to be my client and one of you is not going to be my client. And so practically speaking, I have to, and I explain to them, like, there's a big difference between shall and may, right? And I cannot effectively represent both of you, but what we'll do is I will enter into a relationship with one. I will prepare a letter for the other person that I make them sign. And it says explicitly, I am not your attorney. I am not giving you any legal advice. I am advising you actually to obtain your own counsel, and you are in making informed consent to choose to proceed without an attorney in situations where they might be in a meeting where I'm going through the agreement. I do that to safeguard myself. And then also, anytime we have a hearing, I look at the judge and say, can we do a little colloquy here? And make sure it's very clear that there is no joint representation that is existing in the dynamic.
So I think in that situation, if I like your idea, I think that'll work out, because if they have everything resolved, then as long as we make it clear that we represent one, right?
Then we're good.
Does everybody agree? No. Oh, we have some no's out there.
Oh, so what do you think we should do?
Let's find out.
Who said no? Raise your hand.
And why do you think it's no? I think Eric is.
Because it
Oh.
isn't based on what we
Hold
expect
that
or
thought.
think. It's based on what the potential client views as a relationship. We have to make sure that that non-client knows he is a non-client.
So if you have them sign a document understanding that they are not your client and you have the judge ask them
Have them in the initial meetings.
in the initial meetings.
What if they have questions and they say, I know you don't represent me, but can you tell me if this is a good deal?
I think it depends on whether or not, okay, so answering her questions, on the initial meetings, when you're getting an understanding of what, it depends on, you're going to have to use your best judgment as to what that initial meeting is. Like the initial consultation is probably different than, say, a meeting where you've already engaged with one of them. You're saying, I'm engaging with this person. And you make sure it's very clear on the onset. You wouldn't have the meeting first and then say, well, now I'm going to pick the one I like better, right? You would make that decision ahead of time. But typically one person is doing the consultation. They're not like that one person's calling your firm. It's not both of them on a conference call calling your firm and saying, we want to engage in the joint representation. Typically one of you is, and then you're explaining it to the one, and that's the one who's going to be your client. And then when you have the meeting, you make sure it's very clear. Now, when you're going through the terms, you have to have a meeting with your client ahead of time to make sure that they understand, like, these are the terms that we're proposing. You have to have separate meetings. You can't have all of the meetings with both of them, because that's giving the idea that you're representing both of them. So going to your question, which is, well, what if they have questions?
Right.
You cannot give them legal advice.
No.
You
But what if they want to pay you?
under the table? No, I mean, that's a good opportunity to find in that situation, having 3 different attorneys that you can suggest to them. Like and really emphasizing, you really need to talk to an attorney because you have questions. They are legal in nature, and different attorneys are going to tell you different things. You need to go and talk to an attorney and make sure you're getting the advice you need. Right. Or good old Google.
Google's always
Google
right.
law degree. No. You have to make sure that they are, you have to, at the end of the day, if they choose not to consult with an attorney, that's on them, but you have to keep emphasizing that they need to consult with an attorney. Hi, how are you doing today?
I don't think you should have the other person in the room at all. I think the people choose who wants you to represent them, and you don't have them sign anything, you don't have them in the room, you don't have any contact at all. If they address you, even if it's the courtroom, you say, I will not discuss it with you. I don't know why you would even have both of them in the same room at all. I think you just developed a conflict by having them in the same room.
In that situation, though, what you're saying is that you would never you would never talk with the person because they are an unrepresented party. I think I would differ on that. I would differ because I wouldn't say that I'm only going to negotiate with you if you have an attorney. If they are an unrepresented person, that's saying that there has to always be two attorneys in a divorce. And if they want to choose to represent themselves,
They can be in default or represent themselves, but I'm not going to have them in the room, and I'm not going to negotiate with them, because when you get to the courtroom and they say to the judge, well, he told me when he was negotiating that I didn't have to worry about that. If you've never talked to him, that won't happen.
that's true. I mean, you're definitely taking like the safest approach. But I think that whether you're in violation by being in the room with a pro se person and negotiating and finalizing terms, you're probably not going to be in the OCD. But with that said, if you're ever in a situation, and this is going to be true for anytime you're like, this feels a little like icky. If it doesn't pass a smell test, you have to determine not only for yourself what you should do, but the first thing you should do is get on the horn with the OCDC and say, hey, here's my scenario. Am I okay? In Wisconsin, we have the ability to email our ethics our ethics state bar representative, and they will email us a decision back and tell us exactly what we need to do, and they send it back within 24 hours. It's awesome. But you have the OCDC hotline that you can contact, and they can run you through it as well.
Hey, Erica, I think that perspective is a good one, only because it's definitely being OC about the OCDC.
I like it.
Right? Yeah. But I also think, and I agree with you, that if there's any doubt or if you're unsure, then maybe having the parties in the same room is not a good idea. You definitely need to make sure that there's a line drawn and that the client knows that they're the client and the other person knows that they are not the client. But I think it's definitely discretionary if you want to have both parties in the same room trying to iron out a settlement agreement. But my thought would be, and I know this is something that we put in our settlement agreements, is that who we represent and that the other person had the opportunity to meet with an attorney.
Why would you expose yourself? We've spent 15 minutes on this issue and we haven't resolved it. So why would you or a lawyer even expose themselves to the possibility of having a conflict through which they have to work, which you can't work through it because the parties are opposing. They have opposing interests. So even talking to one, I've had this situation, I won't even talk to the other side. One comes in my office, I deal with that person, I never deal with the other person. What they do for themselves is up to them without any words from me. Because if there are any words from me, like this gentleman just said, they're going to stand up in the courtroom and said, but he said, whether it's a phone conversation or whatever. I would prepare the settlement agreement, give it to my client. That client can take it to his or her spouse. They either sign it or they don't, but I don't talk to any of them, and they're never in my office.
And let's all be very clear. Is joint representation of a husband and wife okay in a divorce? The answer is no. You cannot represent a husband and a wife. What we're dealing with here is really the level of communication and interaction you can have with an unrepresented person and making sure they understand that you are not their lawyer. You need to make sure they understand you are not their lawyer. Now, some of you have the position that you will not be in a room with an unrepresented person, and you can take that stance. It is your practice. You can do that. The question is whether or not it is ethical to have an unrepresented person in the room with you and your client. That's a different situation, and if you have any questions at all about that, it's going to be very fact-specific. I can think of many scenarios where it wouldn't be, right? Where you're just like, there's, the one person who's definitely codependent on the other person, and you're observing the dynamic. You're sitting there, and you're like, okay, this doesn't feel right. And then you have other situations where the other person is completely competent. They know what they want. They just want to come into your office and sign the agreement. They know what you're not sitting there explaining the terms to them. You're meeting with your client, you have your client execute, and then they're coming and executing the agreement. Or maybe you're having a settlement conference negotiation. Depends on the competency of the other person. But I think it's going to be a judgment call that you're going to have to make sure that you run the scenario by your ethics counsel or your ethics the OCDC hotline and getting that information.
One thing to point out, we're not telling you how to manage your practice. We're just giving you scenarios and some tips But the information that we're getting from different perspectives, I like, because that's the one thing that I wanted out of this presentation is to get other people's thoughts and opinions, because as lawyers, we can always grow and learn from one another. So the more participation we can have, I think that's going to really make this presentation more worthwhile to you, and you'll be able to take more from it. But I do agree with that gentleman. We had spent some time. It was a great first example to kind of kick off and get everybody in the mood
Keep
to
it
participate
spicy.
here. Right?
Who had Fuzzy's tacos?
No.
It was good.
So let's move on to the second example.
Okay.
Is that okay?
Yeah, the second example is parent A in a divorce and grandparent requesting visitation that parent A supports over parent B's objection. This happens a lot, where the grandparents come in and they want to make sure that they're securing their ability to see their grandchild. And so the first question, the first step, right, is determining who is the client. Who the clients are in the representation. So who are the two people that we need to identify could be potential clients who are in that room?
I mean, it's parent A and parent B. It's who the client is.
It's actually parent A and grandparent. So those are the two potentials, are the two clients in this situation. Parent A and grandparent, and it could be grandparent A and grandparent B if there are three people in the room, the grandmother and the grandfather and the parent.
Right.
So step 2.
Any participation over here?
Well, we'll just go
Is there
through it,
is there a
just-
conflict?
Yeah. Is there a conflict? Yes, there is a conflict. We have heads nodding. There is a conflict.
Can you consent? Is this conflict consentable?
Raise your hand if you think the conflict is consentable. Raise your hand if you think it is not consentable. Those of you who are raising your hands, have you had the horror stories? We're agreeing. Oh, you can get child support from me? Maybe I don't agree that my parents should have placement rights. Okay, so those of you who think it is consentable, why is it consentable?
Because their interests may not diverge at any point. There's a possibility they'll be in agreement on everything and be on the same team.
For those of you who think it is not consentable, raise your hand again. All right. Why is it not consentable?
You've got the same problems with grandma and son or daughter as you do with two spouses. Things are likely to fall apart, especially if son sees grandma once more time than he wants, or his spouse comes up with some arrangement that splits him and grandma or grandpa apart. It's the same issue. I wouldn't have them in the room either, together. Wouldn't talk to them together. I'd treat them the same as if it was the spouse.
In this situation, it's possible that there's a falling out, right? There's even though it could be going all fine and dandy, this is a situation where I don't believe that it is consentable. Again, run it by your OCDC hotline, because it might be a different situation, right? It's all going to be fact specific, but I've seen far too many situations like this where they're getting along great, and then mom cut me off financially, and I am not happy anymore.
Or has refused to pay my legal fees.
Yes, yes.
So let's go on to the next one, which is one of my favorites, and I've been coming across this a lot in our practice in the different regions that I cover. Engaged couple looking for a prenup.
Holla. I'll do it. Is there anything more conflicting than a prenup? But we're in love, and we just want to memorialize this agreement. And we don't disagree on anything.
And our wedding's tomorrow.
I actually find these ones to be like the most awkward. Prenups for me are always like the most awkward, right? Because I'm like, well, you think that she's like this, but allow me to tell you some stories.
So in a prenup, we got to determine who is the client, right? So let's walk through this example.
All right, step 1. Who are the clients?
Who are the clients?
Fiance A and fiance B. Next one.
All right.
Step 2.
Is there a conflict?
There's no conflict. There is marital bliss going on here. She said, please sit down. Have several seats.
So do we think there's a conflict, or is it, maybe there's not? I don't know.
Yep.
I mean, even if you don't practice in this area, all you have to do is look at the high-profile divorces to know this is one of the most contentious areas, because it's when you're really sitting down with a clear face with your attorney to say, I know you're blissful now, but when they do wrong, what are you willing to give up and what you're not? Right. And it also dictates a lot as to timing in the future. If they get in this marriage and they divorce you next year, it could be very different than if they divorce you 10 years down the line.
Absolutely.
And I think that only an attorney who is representing one of the individuals can really give them that kind of wisdom in that situation.
So we stop. There is no way that you are representing the engaged couple looking for a prenup. And in my jurisdiction, actually, I won't even do a prenup unless the other person has retained counsel. Just the way the guidelines that we have for whether a prenup is enforceable, I won't allow another person to be without counsel and proceed with a prenup.
And I can tell you in other states that I'm licensed in, they have to be represented. So, okay. All right, we're moving along.
All right.
Actually, we're going to have to speed it up. I was a little concerned. All right. I will go sit down.
You can stay up here. So let's talk about you tweeters and you Snapchatters and all the LinkedIn folks out here. We talked a bit in the presentations earlier with Scott Trout and Raul. We were talking about social media in the context of our clients using social media and how that impacts litigation. Now we're going to talk about your use of social media. If you're not on social media, well, good for you. The rest of you, you are one of the billions of people who are active social media users. But as you use your social media accounts in personal and professional capacities, there are ethical considerations that you're going to want to keep in mind. Why do we care? Because the OCD cares. And social media applies to these rules of professional conduct as well as these rules of professional conduct. So the statistics, I know I asked this last year, and I bet there are even more of you, but how many of you blog for your firm? Raise your hand. One. That's one more than last year. So blogging is an effective tool for lawyers to generate traffic to their website or social media page. So the rest of you, the 300 of you, you might want to consider blogging. But as we go into this, we'll talk about some considerations that you might want to keep in mind. When you blog, you can demonstrate your expertise, you can develop relationships, you can drum up business and traffic to your website. However, it's really time-consuming. You can't just have one article, like spend all day drafting this one article, and then they're looking for more, and then they go to another site. No, it turns to an outdated and abandoned blog, and statistically, an outdated and abandoned blog can leave a worse impression than no blog at all. So you have to continue the practice with regularity in order for it to be effective. For the past 4 years, so looking at 2013 to 2016, the percentage of firms that report that their firms have a blog has remained steadily at approximately 26%, with 60% of the firms, 500 or more attorneys, having a blog of their own. In addition to polling regarding blogging, the ABA also polled regarding firm presence on social networks, and 74% of the respondents indicated that their firm, not just themselves, their firm maintained a presence on social media. And as you can see from this graphic, they asked specifically about LinkedIn, in which had the highest firm presence, followed by Facebook, and in 2016, Martindale was up there as well. So this is for all firms, not just the largest firms. And 76% of the respondents reported that they individually use or maintain a presence in one or more social networks for professional purposes. So not surprisingly, the group most likely to report individually using or maintaining a presence in social networks were the respondents under the age of 40 at 88%, followed by those between the ages of 40 and 49 at 85%, and then 50 to 59 years old was 81%, and 64% of those 60 plus years or older. And these statistics have been pretty consistent since 2013. So we know that social media is widely used in the legal profession, maybe not blogging, but maybe in other capacities. We know that the number one reason is for career development and networking, finding top talent and connecting yourself with the referral sources and other job prospects. But it's also for client development that we know. But you can use social media to keep yourself aware of current events and educate yourself. Plug. Check your sources, make sure it's not fake news. And you can also investigate your case. Yep, I do check the opposing parties, as Scott Trout and Raul Sandoval were talking about, by checking Facebook pages in a contested placement case. And fingers crossed on open privacy settings or damaging profile pics. But you can use it in your practice, both professionally and for your firm's professional goals, as well as for your clients' cases. But there are some issues to consider.
Erica, I think I'm going to start blogging and tweeting about my success in court to try to get clients. Is that okay if I do that?
No.
Or I think I'm going to start tweeting about this big client that I retained, and it's got a lot of money, and I'm not going to mention their names, but I'm going to really describe them in detail because I'm so proud of myself, and I want everybody to realize that I can really retain some giants here.
And because you're kind of a big deal?
Kind of.
Yeah.
If I had the mic in my hand, I'd drop it and walk out.
All are no.
All right, well, so let's get back to some of the issues, and we'll give you some tips on how to manage when you're doing the social media in your practice and some of the ethical considerations. So we've got advertising, recommendations and endorsements, confidentiality, inadvertent creation of attorney-client relationships. That's always my favorite one to talk about and get some thoughts and opinions on. And then, of course, investigations. So here we go. A little dry, listen up, and it's going to get fun afterwards. 4-7.2, dealing with advertising. A lawyer may advertise. Well, do we really need to go through this?
I was just going to say.
We don't advertise here.
Raise your hand if you can read.
Do we?
I won't make you raise your... There are a lot of people who cannot read. Raise your hand if you can read.
Maybe they just like the sound of my voice.
Raise your hand if you are taking a nap. No, just kidding. Raise your hand if you want us to not read all the slides and just keep going. I better see it higher. Yeah, we are not reading.
Not reading.
Majority
okay.
rules.
Let's do it. So advertising. How many people here advertise their services? One? It's got to be more than one. 2, 3?
All right.
Really?
We're going to have to do the
Interesting.
exercise again. We're going to do it.
I was hoping
We're
we wouldn't have to.
We're going to do it. Everyone, raise your hand right now. Now, everybody, put your hands down. All right. So what was the question? Raise your hand if you advertise for your legal services. Wow, the rest of you are just like really good at networking. Isn't that advertising, though?
Yeah, that's a
Advertising
form.
yourself
Yeah.
with your business cards.
Well, hopefully they're not tweeting about certain cases, which is why they're getting all these clients, Erica. So one thing that it's important to remember is if you are going to advertise, especially for those handful of people that raise their hand, you have to remember that any advertisement or communication made pursuant to this rule shall contain what kind of disclosure? That's all exactly, right? The choice of a lawyer is an important decision and should not be based upon advertisements. Is that true? So let me ask you this. What is legal advertising? Anybody have any idea of what that would be?
It's not just.
I think we have a...
Yes. It's not just billboards. It's like anything. It's anything. Yeah. So she's what she was saying is essentially that advertising is anything. It's not just the billboards or the glossy brochure pamphlets that you might have.
Right. Where are we at here? Okay. Threw me off since we're not reading some of these slides. So advertising, continuing on. Lawyer and law firm websites are deemed to be advertisements. Social media profiles can be. We're going to go into some detail and some examples about that as some cautionary measures to put in place. What about, let me ask you this question because I don't know the answer to this. So we're going to find out, okay?
Okay.
What if you have a Facebook page and, well, let me back up. First of all, is anyone here on Facebook? Or are we still on MySpace or I don't even know what else was before that. So it's Facebook. Is that still the main form of social media? Right?
You're looking at me. I am not.
I'll have to ask my 3-year-old niece or something. But we'll go with Facebook for right now. Anyone here have a Facebook page? Let's start with that. That's a good question to distinguish. Let's start with personal. A lot more hands were raised. I was concerned. I didn't know if we were sleeping or maybe they're like me and not all that cool and kept up on the latest technology. All right. So on your Facebook page, if you put that you're an attorney, could that subject you to the advertising rules?
Yes. Head nods.
Really? Even so, if I put on my Facebook page that I'm an attorney with Cordell Cordell, am I subject to advertising rules?
Gotta be careful. You can be.
What if I'm just use my Facebook page to communicate with friends and friends only? Am I still subject to legal advertising rules? Do you have my presentation over there? That's a really good point, and we're going to get into that as far as not creating the impression that there's an attorney-client relationship. But the point that you raise is with friends, they may ask you legal questions, right? And so that's something that we got to be cautionary on, and I don't want to spoil the entire presentation, so we're going to table that. But what it states is a lawyer's social media profile and posts are not subject to advertising rules if used solely for contact with friends and family. But advertising rules apply when social media is used primarily for business purposes. So be careful, even if you have a Facebook page that is just personal, if you're posting things on there about your firm or your practice or what you do and results that could cross over and subject you to exposure, liability, and you may have to comply with some of the advertising rules. So is there a tip up there? Fantastic. Avoid using law firm email addresses and commenting about legal matters on your personal social media page. I think that makes sense. I know sometimes we cross-pollinate the two and not really focus or pay attention when we're doing that, but we really need to be careful what we're posting on our personal Facebook page as opposed to if your firm or your practice has a Facebook page.
But what about when Dan posts on my Facebook page, something on my Facebook page?
Man, now we're getting deep.
So if someone posts non-compliant content on my social media site.
So that's a great issue. I I have a lot of friends on Facebook. I'm going to brag up here, and no, actually I don't. But so I'm sure there's a lot of people that have a ton of friends or acquaintances on Facebook. And so what if they post something on your Facebook page that's inappropriate or may not comply with what, as lawyers, we know to be, it could be a violation of the ethical rules. What should we do? I mean, I don't know if I should delete it. Do I contact somebody? I mean, I didn't put it on there, so why should I be subject to this? It's my Facebook page, but I didn't put it on there.
I already advanced the slide.
Oh, you did?
They all
You're
know.
stealing my thunder? Stop it. Give me that clicker back.
You called it a clicker.
What else would you call it?
A remote.
Whatever. Tomato, clicker, remote. All right.
So we have to delete the material, and if the removal is within our control, and if not, you have to ask the person who made the post to remove it. So a pro tip here, if you're looking for something to do, is really just clean up your Facebook and clean up your social media accounts. Yeah.
Let's say, and I know you're talking about Facebook, let's say
You're on LinkedIn.
and on LinkedIn you say, I'm an attorney, so you're now subject to the advertising rules?
You.
Just by simply identifying yourself as an attorney?
So the question was, if you're on LinkedIn and you identify yourself as a person, or as a lawyer, if you identify that you are a person, right? If you are a lawyer you say that you are a lawyer on LinkedIn, you have to be really careful about what you're saying in your profile, because LinkedIn is different, right? Because LinkedIn, your profile is public. It isn't, even though it's your personal account, you're putting all of your about is probably not like, I like cats, cat videos. Can you even do cat videos on LinkedIn? He says you can't. That means he knows. Several. Can you share with me?
So I think what you're raising is a very important question and
It's
issue.
about what you're posting in. I mean, and it's the type of site that it is.
Right, and it's the purpose on why you're posting it too, because you can put on there what your position is or what you do, but is your intent on doing that to obtain clients, or is your intent on there you're just having a LinkedIn profile and how you're using it?
It's a professional capacity site, and you're putting in your about section. If it's all about your practice, it's more of a professional site, so you'd want to be very careful.
So let me ask you this.
Yeah.
Put the disclaimer,
Pop it on there.
and call it a day, and you're done.
That's what I would do. But I would also be really careful with LinkedIn in particular and all those Facebook sites. So how many of you check your Facebook and your LinkedIn every single day? Raise your hand.
How many have just checked it?
If you have one of those accounts, and let me tell you some horror stories, right? You have this LinkedIn account. You don't really check it. You don't have time with all these people who want to connect with you. I get requests to connect with opposing parties from like 6 years ago, right? So when I'm looking at it, I'm like, okay, I can't connect with this person because this is like an opposing party from 6 years ago. So you have to be really careful about who you connect with, right? Who's shutting their LinkedIn down today, right? But also, the other issue is they send you a message, right? But you don't check your messages on that site. And somebody thought that they had an attorney-client relationship because they sent you a message and they were expecting a response, right? So you have to be careful. If you're going to engage in those sites, you actually have to be active in monitoring what you're doing. That's why, I mean, you can post cat videos elsewhere. I mean, you and I, we'll talk. We're going to talk cat videos and how we get our fix if we're not on Facebook or LinkedIn. Yeah. But that's really the issue. If you're going to be on those sites, you have to be active because you're going to get message requests. My jean jacket friend over here was bringing up, your friends and family are the ones who are always the ones who are asking you for all of that free advice. I mean, just always tell them it's a conflict of interest, right? Is that lying? No. But if you have the friends who are sending you messages, what you need to be careful of is that you're responding to the message and letting them know, I am not representing you. I do not represent you professional capacity. So even though you have those personal accounts, you still have to be accountable and make sure you're being cognizant that, you know, you are, everybody in this room, you're kind of big deals, right? And so people are going to go for you for advice, but then you have to be careful about creating the inadvertent relationship, which we're going to talk about further.
No, that's an important point, and we can kind of jump around a little bit since it seems that we're on that topic now. But when someone asks you a question, even though it's silly to respond, I don't represent you, even if it's a family member or a really good friend, they're not, you think, oh, there's no way that they're going to think that I represent them. We need to be careful about that. I mean, even if I have my own family member or friend ask me a question, I always say, listen, I don't represent you. I don't know all the facts. The general law is this, but I highly suggest that you meet with an attorney. We don't want to give the impression that we are representing them. We also don't want to give the impression that they relied on our advice, took that information, and then did X, Y, and Z, didn't turn out the way that they thought it would, and all of a sudden they're coming back to us and we're not best friends anymore. So there's a lot of implications, and honestly, it's just, I think you mentioned it and a couple other people did too, it's not worth the risk, even though they're a good friend or they're a family member. Really, as lawyers, a lot of times, especially in family law, we know that it's the number one complaint, right? I feel like we're targets a lot of the time. So we really just need to be careful in what we say, what we do, what we post, what we tweet, what we blog, what we Snapchat.
Everybody's like, poor us. Really? We're the victims here.
Anything with social media, right? We got to be very careful. And I'm sure I left out a couple of them, but
I don't know any of them.
beyond Facebook, I don't know. All right, let's move on to another important topic, confidentiality. So that is, I have the remote.
You have
the remote.
clicker.
Yes, I do. So is it on there yet? No. Here we go. So, Rule 4-1.6, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by Rule 4-1.6b. What does that mean? And how does it relate to social media?
So you had a bad day in court.
I don't.
He doesn't. Okay, so I did. So, you know, my client, I'm in court. I'm making this up, by the way. So this is not social media. Had a bad day in court. My client completely, lied in court, right? Today, and it was a terrible
client that
case.
lied?
This is not real. All of my clients speak the truth. And so this is a not real situation, but your client, you just had a terrible day in court. Your client lied, and it was terrible. And so you post on Facebook. You maybe use some, 3 letters that mean something happened today. Start with an F, end with an L. And you say, this happened today, and so in Judge Bob's courtroom, it was terrible. Yeah. Now you're in trouble.
Yeah. Any thoughts or concerns on what Erica just said?
Who's taking away my Missouri license? Oh, don't got one. So confidentiality.
Social media creates a potential risk of disclosing inadvertently or otherwise privileged or confidential information, including the identity of current and former clients. So let's go over some tips here. By a raise of hands, who thinks that we can use social media to message about attorney-client communications? Okay. All right, that's correct. Do not use social media. What about using social media to discuss a case? Any thoughts? Should we use social media to discuss a case?
Just don't even get in the habit of it. The minute they send it
But
to
I
you,
have a
tell them.
great result.
Nope.
I won. Full custody, no maintenance, everything. So the next tip is maintain knowledge of security advances and communication forms you use. And then lastly, client or selected representations list with permission only. So let's move on to, if you could click it, please.
So on a tip on the communications with client confidentiality and maintaining knowledge of security advances and communication forms you use, one thing that we do in our firm is all of our clients sign an authorization to allow us to use email and the inherent risks of using email if we have email communication. So if that's not something that you have in your practice, pro tip, write it down. Have some sort of authorization from your client in order to communicate via email, because there are significant risks to using email. There's also risks if they're using an employer account email that's getting routed through their IT department. So make sure you get yourself an authorization for your clients to sign at the time they initiate representation.
By a show of hands, how many lawyers in this room have a website for their practice? I would have thought a lot more, unless I can't see.
They're just like, they're doing the halvesies, the holesies. How many of you are going to do the exercise? Really?
For those of you who raise your hand and have websites, how many of you allow anyone to post on your website? Post.
Do you mean everyone, or do you mean each person?
Anyone.
Do you mean let anybody?
Correct.
Or let everybody?
Well, let somebody who's not an attorney, if they're just Googling your name, they see your website, they click on it, and they want to ask a question. Do you allow that?
I have seen it. I have seen it in some firms' website that you can post a question online and.
So is that okay to do? I'm wondering if that's even possible. Can you do that?
Yeah,
So with that question, what I'm getting at is, I'm being facetious, is can you answer that? And if so, no? And if you choose to do that, what do you think we should do? Right. Because one thing we want to be aware of, if somebody's going to post or ask a question or even email you, if we respond, we want to make sure that we're not creating that attorney-client relationship. I know we spoke about this a few times throughout this presentation, but Erica and I can't stress enough the importance of this topic, not necessarily just from our perspective on an ethical standpoint, but from a layperson's perspective. We don't want them to rely on something where we don't have full disclosure, we don't have 100% knowledge of all the facts, rely on just general information, perform an act, and then come back to us and say, well, I relied on what you advised me. So we have to make sure, if you're going to go down that road and answer questions, that it's more in a general form, that you're letting them know you do not represent them. This communication does not establish an attorney-client relationship. Do we have that rule up there still?
Yep.
Well, that's okay. It's Rule 4-1.18. A person who discusses with a lawyer the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. An attorney-client relationship may be formed through electronic communications, including social media communications. So again, be very careful on Facebook. Be very careful if you're tweeting or retweeting. We just really need to exercise extreme caution in what we're posting and what we're communicating about or even responding to on social media.
So do you have a tip?
Of course. So the tip is it up there yet? No. If the objective purpose, and we've talked about this earlier too, is what is the purpose of that communication? What is the purpose of your response? And so let me read it out here for you. If the objective purpose of the communication from the consumer's perspective is to consult with the lawyer about the possibility of forming an attorney-client relationship regarding a specific matter or legal need, then an attorney-client relationship has been formed. So again, we need to be upfront if we're going to respond or communicate or send an email, regardless of whether we think it's innocuous or whether we're just being nice and polite. It's not going to help us out if we are subjected to the OCDC. So really, in these situations, Erica, I am extremely OC about this particular issue. So where are we at here? I know we're kind of jumping around. Inadvertent creation. All right. So we've talked about do not elicit or respond to questions about specific situations. Again, even if it's a good friend or a relative, we really don't want to expose ourselves to that liability. Discuss general principles and trends, but caution on variations in application by different areas and in different circumstances. We want to emphasize and re-emphasize the unique quality of legal advice and that what you're providing is not legal advice. And that's important too. Not only do we want to have these disclaimers that this is just general information, I don't represent you, the choice of a lawyer is an important consideration and should not be solely based on advertisement alone, but we also want to make sure that if we are going to respond, that we're letting them know that this is not legal advice. Do not take this response as legal advice. I mentioned this earlier, recommend that an attorney be sought. Disclaimers can be undercut by actions. You can list and follow the steps that Eric and I have been talking about, which one is great, but then two, if you do all that, but then really go into detail, it doesn't make any sense. So all that extra caution that you put into that response or your thought or trying to really prevent yourself from being exposed to liability is for naught, because then that does subject you to liability and some potential issues with the OCDC. So is anybody in this room an expert or a specialist? Can we be experts and specialists? Any thoughts? Let's do this then. By a show of hands, I'm hesitant, Erica. We don't really get a lot of response here. I think lunch is still kicking in. By a show of hands, how many of us in this room are an expert?
We have one. And you are an expert in? Law.
How many
Law.
in this room are a specialist? By a show of hands. And I'm not raising my hand, I'm just an example.
Nope.
Okay. So this I thought was interesting when I was doing some of the research for this. So 4-7.4, a lawyer may communicate the fact that the lawyer does or does not participate in particular fields of law. A lawyer should not state or imply that the lawyer is a specialist unless the communication contains what?
That neither the Supreme Court of Missouri nor the Missouri Bar Reviews or approves certifying organizations or specialist designations.
That sounds like a disclaimer.
It is.
Perfect.
That's gonna be my next job, just giving disclaimers.
You would do really well at that. So what about posting that on your social media account that you're an expert or a specialist? But it's your Facebook page. It's not your firm's Facebook page. What do you think?
Shaking heads. Doesn't matter because, as we talked about, your social media page can be your advertising.
Yep. When you create a social media account and complete a profile, is a social media platform branding you to the public as an expert or a specialist or as having legal expertise or specialties? So there's, who here has heard of, well, we talked about LinkedIn, but who here has heard of AVO or AVO, AVVO?
I don't know what it is either. Does anybody know like what it actually is? I think it's AVO. Bavavo.
We'll call it AVVO. So in LinkedIn and in AVVO, AVO, we got to be careful because sometimes there's a default, and the default could brand you as an expert or a specialist. That's something that I didn't know, but I thought that was very interesting when I was preparing for this presentation. What about solicitations? Do you think do they fall under here, whether we're handing out brochures or if we're just sending out mass emails?
Well, if we're talking about it, it probably is.
Yes. So, and do you think that there's a rule that applies to this?
Ta-da!
Perfect. With the clicker, too. 4-7.3 applies to in-person and written solicitations by a lawyer with persons known to need legal services of the kind provided by the lawyer in a particular manner for the purpose of obtaining professional employment. Oh, man, I'm tired of talking up here. Let's go through some examples. So the question, should you evaluate before sending any public or private social media communication to any other user?
I don't know. Raise your hand if you think yes. All right.
Is it just a blanket yes? No. You must consider who the intended recipient is and why the lawyer or law firm is communicating with that particular person to avoid prohibited solicitations. So let me propose this to you that I wrote down. You're not spoiling my, oh, you are.
I'm not giving the answer.
Okay. So, are you unintentionally soliciting when you import email address books to send friend requests or invitations? By a show of hands, who says yes? Who says no? Who's?
So I'll give a scenario. Do you all remember when LinkedIn, I don't see it as often anymore, but do you remember when LinkedIn would, when they first, it was more like 2 years ago, and you would sign up for LinkedIn, and you know, you're lawyers, so you don't read all the disclaimers. You just click yes because you know it's non-negotiable, right? So you didn't read all of it, and then all of a sudden it imported your email and sent an invite to LinkedIn to everybody you have ever emailed. Yeah, you guys remember when that happened? Okay, so are you, when that happened, unintentionally soliciting when you sent that email? Yeah. Yeah. He set up a Facebook business site. And then it said invite your friends to like your page. It sounds like a solicitation. You mean like when you were soliciting people to like your page? Was that a solicitation? It was an invitation. I'm getting arrested for inviting, not soliciting. Right? I wasn't soliciting, I was inviting. You're such a lawyer. It's a solicitation. Well, in order to like it, you need to experience it.
It depends if this batch goes out or.
It is a solicitation. Okay.
You are asking your friends to like your page. You're
Yes.
not asking your friends to choose to do business with you. It's a business page, but all you're asking them is basically to promote your page.
Correct.
By liking your page.
You're asking them to engage in advertising for you. Yeah. Sorry, honey. I'm just shut it down.
Well, this is why we're up here for you.
You know, they're actually.
We're here now.
And just so you guys know, like those of you who are struggling, I mean, the social media stuff is like complicated, right? And then you hear about all these laws, and they're like taking all of your private information, and like I don't know, like taking my credit card, and I don't know what all they're doing. But just so you know, there are actually companies that you can hire for your firm if this just feels like, you know I need to be on it in order to get the business that I need, but I'm just worried about all these issues. There are companies out there who specialize in social media marketing, and they will handle it all your invitations for you.
But we are lawyers and we don't know this.
Yeah.
How do we know those companies are going to know it?
Exactly. That's why you would want, that's a concern, right? You want to make sure that the companies know what a solicitation is, and it's complicated. It's not easy.
And you also got to remember that when you send these batches out, it could be with someone that you may not be able to communicate with if you're just accepting every friend request or every LinkedIn invite. One other thing to remember is in some of these sites, they send out, so if you send out a friend request or an invite on LinkedIn and somebody doesn't respond, then it's an auto send. Yes. And then if they don't respond again, sometimes they send it out twice.
And then, and if it's anybody you have ever received an email, like I've gotten emails from unrepresented parties and then they're represented, but I don't email them, but I've received an email from them, and then all of a sudden I'm now communicating with a represented
Right,
party.
exactly. So we just got to be cautious on what we're doing. As an aside, Facebook does that as well, too. I've gotten several requests from people to play Candy Soccer Crush, and I have no idea what it is. I don't play the games, and I ignore it because I just, in my head, I'm like, I'm not going to do this. And then I get another request, and then another request. I'm like, what is this person doing? Clearly, I'm not responding to you, so why are you still sending me these darn requests? So doing the research, I figured out, oh, there's an auto
And
response.
they want extra lives. They get extra lives.
And it's at odd times of the day, too. And so I'm like, shouldn't you be working? But well, names will remain anonymous, but I'm like, Anyway, so I'm going to read something to you that is going to be mind-blowing, so don't steal my thunder. So don't use the clicker, okay? Every reminder could constitute a separate violation of the rules prohibiting solicitations. So, very, very worrisome and scary. Let that sink in for a minute. We don't even need to buy time here, Erica. So we'll continue to move on. If you want to
I did.
click. Oh, okay. Phenomenal. So, who are you able to ethically communicate with on social media? There's got to be somebody I could communicate with, right?
Your mom.
Maybe my sister?
Just your mom, but make sure your mom understands this is not an attorney-client relationship.
Same thing with grandma. But can we communicate? Right, exactly. What?
She spent too much for a license. That's a good
We
one.
work way too hard to subject ourselves. I agree with that. So who can we communicate with? Other lawyers? Sure. Family members? Why not? Close personal friends, persons with whom you have a prior professional relationship, and persons who you have specifically requested or who have specifically requested information from you. Now, this next slide I think is somewhat silly. We all probably should know the answer and how to approach these types of situations, but do you have it on there?
Yep.
Does that really say communication with represented parties? Should we communicate with represented parties? Is that okay?
No.
No? All right, well, there's a rule to that, and it is Rule 4-4.2. What about Facebook requests or LinkedIn invites? Again, I know we've talked about it, but if you're getting a Facebook request or a LinkedIn invite from a represented party, you need to be very careful. So we're on to the next slide here. All right. We are prohibited from engaging in social media communications with persons whom you know to be represented by counsel. So you may not send Facebook friend requests or LinkedIn invitations to opposing parties known to be represented. All right, so I can't do that as an attorney. I mean, that's, I guess, fine, whatever, right? We won't communicate with represented parties. Mind-blowing rule right there. But what about other people in my office? What about paralegals?
Nope.
You don't think so?
Nope.
Let's take a poll. I feel that we're getting a little more energy in this room.
Okay.
By a show of hands, can paralegals communicate with represented parties?
If you think yes, raise your hand. No individual sessions needed.
Wow, we
We're
have
good.
a consensus. That's great. All right. Well, how about this? What about secretaries?
Same thing.
Law clerks?
Same thing.
Right. So
Yes.
the rule. Oh.
That there's an issue your friend has that you want to talk about.
My concern with the breadth of how we're painting this, if I'm connected to Fred, who's connected to Sue, and Sue is connected to opposing counsel's represented party 2.0, okay? I am connected to them, but I'm not connected. You know what I mean?
I know what you mean. You're connected but not connected.
Exactly.
Just don't accept that person's friend request. Don't send them any messages.
Well, the messaging I can understand. The direct messaging I can understand. My concern is if I'm tagged, I'm just new to social media, so you have to forgive me. If I'm tagged some way where I see something that they've posted on their thing through a friend of a friend of a friend,
Can you go to
Communicating with them, but I got tagged via the communication.
In that situation, I see it as no different than like, oh, we're all at McDonald's at the same time. Do I need to leave the McDonald's? No, you don't. You can enjoy that Big Mac. Just because somebody else is there, you can also be in the McDonald's. But you're not going to sit at the table with them and share a Big Mac. All right? We're getting our visual here. Yeah. Just don't friend request them. And if I think in that situation, if I was like tagged in a group post, like let's say I went to an event and you have that one friend who like tags everybody to everything, just untag yourself immediately. That's what I would do.
Or send a request to that person to do it if you can't do
And
it
there
yourself.
actually are now security settings in Facebook, for example, that you can set when you can be tagged in another person's photo and when you can be tagged in like into a message. So you can limit your profile from being referenced in those in your Facebook settings. It's fairly new within the last couple months.
My other big question is about the LinkedIn and Facebook. You said if you put that you're an attorney there, you need to have the choice of an attorney as an appointed one. Should that be on everything that you have?
I would put it on there if I was in Missouri. If you wanted to be super safe, I'd say if you wanted to be OC about the OCDC, if you're using your business card as marketing, I mean, right? We can imagine situations where it could be marketing, where if you're going to events and you're like, let's say I just handed out all of you my business card in case you're in Wisconsin and want to divorce your spouse. Just kidding. I'm trying to keep it light, folks. But if that's the situation, I mean, I can see it getting a little like, that's passing a smell test versus just being your information that you have available for your clients. Like, I'm not the kind of person who hands out my business cards.
I think and that's a really good question that we probably should put on for next year to add it to our list. But my thought would be you don't want to post on your post. I'm still stuck in posting right now. You don't want to have on your business card that you're an expert or a specialist because you got to comply with the advertising rules. But if you also don't want to put on that you guarantee results and things like that. But as far as just having your name and you're an attorney, I think that part is okay. It's just what is the intended purpose of that card and what is the information on there. But that again, it's something for all of us to think about. We definitely want to be cautious and we definitely want to be OC about the OCDC. One thing that I also found interesting when I was preparing for this presentation is that there are some social media sites that automatically notify members about who looks at their profile or post. This notification may result in unintentional communication with a represented party.
Yeah, LinkedIn does that. For example, if I were to go at somebody else, if I would go on and review Dan's page, he could see like who's checking out your profile, and it would be a picture of him, a picture of me, and he would be able to know that I was on his Facebook page or his LinkedIn page reviewing it for evidence. It sends them a notification that so-and-so is reviewing your profile. It's just it's giving you a, be careful. Go ahead.
I mean, doesn't it have to be in regard to the represented matter? I mean, that kind of thing that you're talking about has nothing to do with any of the representation that you're talking about.
So the scenario is somebody comes into my office, and I don't do it on LinkedIn because I know LinkedIn does this. So Bob client comes in, his wife Sue is on social media. So I will go on her social media sites, specifically I look at Facebook. I don't typically look at LinkedIn, but you might want to look at LinkedIn and see, oh, the person's they're claiming they're unemployed and unemployable. I might want to check out their LinkedIn page and what are they telling potential employers about their great skills that they have, right? It's going to potentially send them a notification. Yeah. I'd probably have my client do it, right? Not me.
All right, so there's a rule associated with communication with unrepresented parties. You can look it up, but we have it here on the screen shortly, which is 4-4.4a. So let me propose this question because we're in a really good groove here. Are you allowed to use social media to obtain information from third-party witnesses that may be useful in litigation? Any thoughts on that question? All right. Well, by a show of hands, who thinks yes? Who thinks no? By a show of hands. Who isn't listening? By a show of hands. We're almost there, folks. We're almost there. I see the finish line. So let me ask it again, and I'll tell you the answer. Are you allowed to use social media to obtain information from third-party witnesses that may be useful in litigation? Yes, if the information is publicly viewable social media content. However, if the information is private, then ethics limit obtaining that information. You may not obtain private social media content by using trickery, dishonesty, deception, aliases, all this information that we've been discussing as far as how to get information in a way that doesn't comport with the rules of ethics. What about using social media to do investigations? I know, Erica, you just touched upon that. To do employment background checks, find information about opposing counsel, judges, witnesses, experts, jurors, that's fine. I know Scott mentioned earlier this morning, before he goes into a meeting, he likes to know who the potential client is and maybe who their spouse is. That's all just being proactive. It is okay to access public social media pages. What about to friend under false pretenses?
It's almost like it's dishonest.
Right. Well, you're stealing my thunder again. You know, give me the clicker, please. You're clicker happy over there.
I don't think he knows you guys all have the slides. They all have the slides in front of them.
I'm just telling myself up here. I'm having fun. You know, I told you, this stuff scares me, so I'm going to make sure that it's communicated properly. I don't want you just to read what's in front of you. We want to discuss it. What about investigations? As long as you did not instigate or aid the client in overreaching with respect to the represented party, then this is allowed. Try to move through this a little quickly. I see the signal that I was told I would be given, so I appreciate that. We're there, folks. We are there. Let's jump to a tip. It is important for lawyers not to obtain access to social media by surreptitious means and not to accuse other lawyers of having done so without good cause. Do we have more? We do have more tips in there. Create guidelines, as Erica said in the very beginning. Really, the importance of this presentation, of course, is to advise us of what our risk is and what liabilities we have. But I agree with Erica, and when we were talking about this, we really just didn't want to come up here and present. We really wanted to try to be funny, so hopefully we were a little bit funny. But most importantly, we want everyone here to take this information and to develop an action plan. And Erica said it best. We really want you to walk away, this is what I'm going to do, this is how I'm going to treat certain situations, and really kind of open up your mind and your eyes and ears to what is out there. So create guidelines on how to use social media with an emphasis on education about the issues involved. We have one last topic, which I think you just got a couple minutes, and it is resolving disputes with clients.
So how many of you have ever had an upset client? Happy clients, right? So we have the rule there, and all of you are literate, so you can read the rule 4-1.16 on declining or terminating representation. So we wanted to go through a few scenarios to give some tips and tricks, right? So that we're all leaving with an action plan on something that we might want to do different in our practice to address some client concerns. The first one is disputes regarding billing. And I'm going to break down the scenarios, identify some tips and tricks for resolving clients' dispute. And the first thing to remember is that we're all here to serve our clients, right? We're in the service industry. So to avoid situation where a client's upset and goes straight to the OCDC, you must be open to receiving and addressing your client's concerns. So in our firm, we have individuals who are dedicated to that in getting information and feedback from our clients throughout their representation to make sure they're getting the level of representation that they deserve, but also to make sure that if they have any concerns that we're able to address them right away. And there's, as we talked about the violations, excessive billing is a complaint that there were quite a few complaints for excessive billing in 2015. So you're going to have these complaints where clients are upset about their bill. The first question you have to ask yourself is, are you sending your clients regular invoices? That's going to be the first step to addressing and avoiding situations where you're getting an OCDC complaint based on a client having concerns regarding their billing. So you want to make sure, if you're not doing so already, to make sure you're consistently sending invoices to your client. And whenever there's a client who has an issue with their billing, the first thing I'm going to do is I'm going to send them their bills and ask them to identify which billing they had specific concerns about. Right? So that you make sure that you are expressing that, I hear you, you're upset, let's talk about it, let's break it down. So which billing entries in particular do you have concerns about? And then have a conversation with the client and talk about it. So it's not just an issue of like, oh, you're too expensive. Like, this shouldn't have cost that much. I could have done this myself. Really? So you want to make sure that you are going through the bill is the key there, is to go through it with the client and be open to hearing the concerns the client has. And by identifying and addressing the client's concerns, you can avoid a situation where the OCDC is involved. Now, what about those clients where they want you to take a course of action that you find repugnant? Where you want to say to the client, that's just not how I roll, right? Or I'm not going to meet with you in the same room as your spouse. The big thing that I do is I look at a step-by-step approach. So first, I identify the issue, right? Oftentimes, it's my client sending me an email, sometimes 3 o'clock in the morning on a Saturday night, if you know what I mean. Like, oh, you have this grand idea of what we're going to do in your representation. Ooh. So first, I identify the issue, right? And then I will schedule the client to come in for a meeting, ideally in person, where we're going to sit down and we're going to go over that email. I'm going to print out that email. I'm going to have it right in front of us. And I'm going to show it to the client and say, I want to go through this because I want to make sure we're on the same page as to what your email is asking. And the client may back off of the position. And that's why it's important to have that meeting. As people, not just lawyers, we don't like to have difficult conversations. You want to avoid the difficult conversation if you don't have to, right? But don't be that attorney who immediately sends an email to your client that's a nasty-gram to their nasty-gram, which is just inflaming a fire, right? So you want to sit down with your client and discuss, this is what I understand your email says, confirm that you have the same understanding, but also go over their concerns and your concerns regarding what course of action they want to take. I always find it important to relate it back to the goals they had at the beginning of their representation. So in the beginning of my representation, I outline what's important to you. And then I relate this back. Okay, you're wanting to do this, which has nothing to do with what you said that you wanted to do. So let's just make sure we're on the same page. That this is now what you want to identify as your goals. And make it clear what you are and are not willing to do in the representation. And then give the client the choice and say, you may find another attorney who's willing to take that course of action, but that attorney is not me. And under Rule 4-1.16, if it is a course of action you are not willing to take, you have the ability to withdraw, but make sure you're following the guidelines, addressing the issue right away, so you're not putting your client in a situation where they're close to trial and you have an issue there. Next is the positive or posting of negative feedback online, and this is our last one. More and more potential clients are reviewing online reviews before deciding who to retain. But what do you do when a client posts negative feedback? One thing that you can't do that you really want to do is you cannot respond to the post specifically with that client. Well, actually, if you wouldn't have done X, Y, and Z, you cannot respond to the post. You can, however, address the concern with the client. That's an idea that you can do, because sometimes those negative posts online, when people are going online, they're reading more of the negative posts than the positive. You can have 500 positive reviews and people are checking out that one negative review, right? So you can take the time to reach out to that client and actually have a discussion about their concerns, because one, you might change their mind. You might be able to find a mutually agreeable resolution, and you could even potentially agree to a non-disparagement as part of that. Yes, ma'am.
Now, when you say that about, now, of course, we're attorneys, we have to be professional at all times. But is it, you're not saying that you can't post something such as, I'm sorry you had a bad feeling about it, or something like that?
I would not post anything at all. So if he posted, or he or she posted a negative Google review, I wouldn't touch it by responding, because you're running a terrible potential for confidentiality breaches, right? So I would reach out to the client myself outside of the internet world. I would leave it there and then talk to them, and potentially they would bring it down themselves. So that would be the route to go, is you're better off amending that relationship, if possible, to remove the negative post. That's the route I would go. All right. Yes, sir. Yeah, so what if you don't know who posted the negative? A lot of the sites actually are making people that they can't post anonymous. But if you don't know, I mean, do your best to try to figure it out, right? Like, oh, it happened to be Thursday. I had a bad hearing on Wednesday. I wonder who it could be. But a lot of the sites are actually making them put their information in, like the Better Business Bureau, so that it's not just, you know, Joe Schmo firm down the street who doesn't like you and you're taking his business and he's posting fake reviews on you. And so try to figure it out the best way that you can. But typically it has like their first name and their, like the start of their last name. Like Jason W. On Google, yes, there is. Did I see another hand? No? Well, everyone, congratulations.